and the presiding chair of the U.S. Senate, Senator Mike Lee. And all of us here today know the fight to protect our Constitution and American civil liberties is far from over. We must remain vigilant, and we must also ensure that we have robust and transparent debate about these programs and what reforms must be implemented to protect America's civil liberties. And this is why I support the USA Freedom Act, which would end the NSA's bulk metadata collection program, and why I strongly believe that Congress must engage in an open amendment process. The American people must have their voices heard, and an open amendment process will help ensure that happens. In light of all we have learned about the NSA's unlawful bulk data collection program, it's clear that reforms must happen. It's critical that Americans' rights are protected against the overreach of their own government. So I asked the senator from Kentucky, would he agree that the indiscriminate government collection of Americans' phone records violates the Constitution and, according to 2 independent commissions, has not proven critical to our national security?
I want to thank the senator from Montana for that excellent synopsis of things and also for the great question. I think that the reports by the Review Committee and the Privacy Committee, both commissioned by the President, both nonpartisan, are incredibly powerful. Because not only did they look at the constitutional issues of whether or not this is a bulk or a general warrant versus an individual warrant, they also looked practically, was it working? Was it adding anything to our intelligence? And so I think you have sort of a dual reason now to say this is a big problem. One, there are constitutional questions, which I think are very clear. But then there's a second practical question that when you examine the evidence, and the Privacy Commission actually looked at classified evidence. They looked to see whether or not it was adding anything to this. I'm thoroughly convinced that we can catch terrorists with warrants. When I've talked with traditional constitutional warrants, when I've talked to those who are the high-ranking former heads of our security, they freely admit they get more information with a warrant. It's a little more work, but it has to be more specific. But I'm also a believer that because we've generalized what we're looking for and it's indiscriminate, that maybe we're missing people because we're overwhelmed with data and we're overwhelmed with things at the airports. You know, I would much prefer to have less of the indiscriminate searches at airports and more specific looking at the manifest of who's flying, you know, and looking and trying to find who are at risk. So I do think that there's, without question, this is not a constitutional program. It's not even legal under the PATRIOT Act. The courts have said it isn't, and we should do everything we can to stop it. And I appreciate your support on that. One of the things about this issue is that it really is a bipartisan issue, and an issue where there are people who feel strongly on both sides of the aisle. We had the senator from Oregon earlier and the senator from New Mexico, and I now see the senator from West Virginia, who is also a loud and consistent voice on this. Do you have a question?
Mr. President, will the senator from Kentucky yield?
The gentleman yield.
Without yielding the floor.
You know, I know that the senator, my friend from Kentucky, agrees with me that the defense of our country and the protection of our civil liberties should be bipartisan and above politics. And I know that he agrees that we can and must protect our citizens without violating their civil liberties. And again, my good friend, I don't always agree with you on every issue, but when it comes to this nation's intelligence gathering and security, we agree more than we don't. Like him, I was deeply troubled by the revelation that our country was engaged in bulk collection. I think we all were surprised. And millions of private citizens' data was gathered unknowingly and unjustifiably. In 2013, Edward Snowden revealed to the American public that the NSA was engaging in the bulk data collection and sweeping up virtually every cell phone record of an enormous number of Americans, again for no reason and no cause. The U.S. spying program did this by systematically and indiscriminately collecting millions, I mean millions of American phone records by simply taking up every phone record that came in its net, even if it wasn't remotely related to the broad general search. These are not searches that were relevant to a particular thread or an individual group. It was just a huge database documenting what millions of law-abiding citizens were doing. That is not what this country was based on, and I think you've made that very clear, sir. And I know that you believe that this was wrong, as I do. And that is not just our opinion. National security experts, legal experts, the American public, and even several courts have said that the bulk collection of data is not only unconstitutional, but also unnecessary to our national security. And to my friend from Kentucky, he has confirmed that the President's Review Group has said the bulk data collection is not essential to preventing attacks, and that program has not made a difference in a single instance. The bill that the Senate will soon be considering, the USA Freedom Act of 2015, will ensure that we restore important privacy protections for Americans. The United States will always face security threats. I think we all know that, and for generations to come. That's just a reality. On that horrible day, September 11, 2001, we as a country were reminded of this fact and realized we must meet those threats with strong law enforcement and strong intelligence. However, we must also balance that necessity with our constitutional rights. The NSA bulk data collection program clearly did not strike that balance, and the District Court of D.C. and the Court of Appeals of the Second Circuit of the United States struck it down. The courts have made clear this program is not legal, and I understand Senator Paul and Senator Wyden's frustration with any suggestion that it be continued. I believe this bill, USA Freedom 2015, moves us in a positive direction. It ends the bulk data collection program and ensures that the collection of data is related to a relevant, particular terrorist investigation. At the same time, it still protects this country. The USA Freedom Act of 2015 replaces indiscriminate bulk collection and allows the government to collect call details of records on a daily basis if it can demonstrate to the FISA court a reasonable, articulate suspicion that its search term is associated with a foreign terrorist organization. The bill provides greater transparency about surveillance activities. It contains significant new government reporting requirements for FISA authorities to ensure its activities do not again break the law. It gives private companies increased options for reporting to the public information about the number of FISA orders and national security letters that they receive. The bill requires declassification of FISA court opinions containing significant legal interpretations. The bill requires the FISA court to designate a panel to appoint individuals to advise in particular cases involving new or difficult legal issues. It expands the opportunity for the appellate review of FISA court decisions. The bill strengthens the judicial review process for gag orders. It imposes new privacy protections for FISA pen registers and limits the use of unlawfully obtained information. And the bill also contains many provisions to protect our nation's security. It creates a new emergency authority to allow the government to obtain business records, including call detail records, without advance court authorization, if an emergency requires those records. It also adds a short-term emergency authority for continued transnational surveillance of foreign terrorists or spies who come into the United States before emergency authorization can be obtained from the Attorney General. It permits ongoing FISA surveillance of an agent of foreign power who temporarily leaves the United States. It clarifies that individuals can be subject to FISA surveillance if they are knowingly aiding, abetting, or conspiring with respect to the proliferation of WMD on behalf of a foreign power. And finally, the bill increases the statutory maximum penalty for material support of terrorism from 15 to 20 years. Now, I know the senator from Kentucky does not think it goes far enough in protecting our privacy rights, but perhaps my good friend can remind us again on what provisions that you would like to see changed or strengthened in the bill to satisfy your interest and maybe Senator Wyden's interest and other people. I would yield the floor back to the senator from Kentucky to hear basically his concerns of how we can have some protections, and do we have any rights whatsoever to gather information when it's proven. I've heard you say that you thought if we could prove it, if there was a definite concern that we had, you can get FISA courts and basically move forward from there. I thought this bill moved us in a positive direction. The new bill we're considering, or about to consider, sir, if you could explain to me maybe your concerns about that or what we need to do.
Let me make sure I have the question correct. Your question is on the USA Freedom, my concerns on the USA Freedom?
USA Freedom 2015.
Yeah. I want to like it, and I want to because it ends bulk collection, and I'm all for ending bulk collection. So we all agree. The people for it agree with the problem. It's a question of whether it's a solution. It says that there have to be specific selector terms on U.S. persons. Part of my problem is that persons is still defined as corporations. My concern is that you could put the word Verizon in there and the government wouldn't be collecting the records, but you still could get all the records from Verizon. You see what I mean? Because that's one of my concerns in the way it's been written. And my other general concern is that would we still be having bulk collection therefore, but it wouldn't be all done by the government, but it'd still be bulk collection through the phone companies. And I don't like the liability protection because I think it makes it more likely than not that your privacy agreement won't be as respected if they cannot be sued for violating your privacy agreement. Those are a couple of concerns. I don't know if they're insurmountable, but those are a couple concerns.
I think we both agree. I think mostly everybody in this body agrees that the bulk collections were wrong. They were proven to be illegal and should not have been done and should be stopped. I think we're all in agreement to that. We still know that we face considerable threats from around the world on a daily basis, if not even greater than that. And we were looking for trying to find the balance, and I think that you are valuable in helping us find that balance. I really do. And that's what we're looking for. And I know that your colleague, Senator, and my colleague, Senator Lee from Utah, has made a gallant effort trying to find that balance and making sure that we didn't overstep. The private companies are collecting. They already have that information anyway. It's not just sweeping from NSA as they had been doing. And basically, I'm understanding by this bill, the 2015 USA Freedom Act, where basically we'd have to demonstrate to the FISA court reasonable, articulate suspicion that its search term is associated with a foreign terrorist organization. They can't even go into those records until that's shown. That's the way I understood it. I'm not sure if there's something I'm missing.
Yeah, I guess the question I have is that we had some of those restrictions now, but they seem to think that those restrictions don't apply to collect. You know what I mean? The people interpreting what we have now are interpreting 215 to mean we can collect all the American records in bulk. If there were a way that I was necessary to pass USA Freedom and it were that close, if people were willing to look at the bill and say, we would make a person an individual. See, the big thing for me is that a warrant should be individualized. And I'm worried that when you use the word person, if it can be replaced with the word Verizon, and we could still collect all the records, I would feel really disappointed if we thought we got rid of bulk collection, and then a year or two from now, when they finally admit it, they'll admit, oh, we're still doing the same thing. We're doing Verizon, and we're getting all of Verizon's record. We're just making them process it, and we're paying them for it. That's my fear. Is I want to make sure that doesn't happen.
I guess we're caught in that Citizens United decision, it sounds like.
In a different way. But I mean, we are talking about whether or not in the intelligence selector numbers, whether or not a person is a corporation and whether or not you can have a single warrant. See, I think if you want phone records from Verizon, it would say Verizon and we want the records of John Doe. It shouldn't just say, we want all the records from Verizon. That to me is a general warrant. I'm still fearful that the USA Freedom Act may not limit that.
If the Freedom Act as it goes away, okay, the way that they've been doing bulk collection, which we agree should be done away with, and we don't come to some agreement, are you concerned that we might be in more jeopardy by not having something in place to where we're able to get the necessary intelligence we need?
And I guess that's where I also probably differ. I think we are just as safe or safer with nothing because the Constitution allows the searching of records. And I'm all for it, but I would do it through warrants. And here's the thing is data, metadata, you can do a hop or two with these less than constitutional warrants or whatever, but with a real warrant, you can go 100 hops into the data. So I really would chase the rabbit down the hole. I mean, I really would look very hard with suspicion, and I think warrants are generally easy to get. This is a point that I don't get about why we have to have warrants that have a lower constitutional standard, because I think that the FISA warrants are almost never turned down, but neither are criminal warrants. If you are a policeman standing in front of a house, you almost never get a no, you know? But if you're a policeman and you say, I want to search all my neighbors' houses, judge is going to say no. And that's a good thing, you know? So I think traditional warrants, I think people have somehow just convinced themselves we can't catch terrorists with traditional warrants, but I think you can go through a lot of data with traditional warrants too.
Basically, that if it sunsets, the bulk collection, the way the PATRIOT Act has been enforced before, sunsets and it goes away, which we agree. We were trying to replace that before the sunset. You believe the system that we have in place today, I mean the system we've had in place before the PATRIOT Act of 2001, gives us still the ability to keep the homeland safe using the court system, as you say, follow the rabbit down the hole, using the court system. Let me say because we know we have rapid fire coming at us from different directions and people trying to come into this country and do harm. The social media has blown up since even 2001, so we're much more vulnerable from that standpoint. And what I'm hearing say also, you're not really objectionable, and if you can find the right language in that freedom, if you thought that you could get to that protection of that individual without the interpretation of the entire broadness of the corporations.
Right. I think that also within the context of, we have 6 or 7 amendments that we'd like to introduce. Can't guarantee that we can win any of them, but there's a chance maybe we could win another reform. So for example, one of the reforms that some people think may be as important as all of the bulk collection is the ability of the government to tell an internet provider that they have to create a backdoor to their product for the government to go through, and some of the backdoor stuff through 702. We think there are some other things that may well be as big as this. I also think that there is the ability of the government not only to use traditional warrants, they have some they're using under executive order as well as we still have, you know, a host of other types of warrants and subpoenas being used. But I would never be for this in a heartbeat if I thought it was going to make the country endangered. I think we'll be safer because of it, and so will our liberty.
The good point of the bill that we will be considering, which is the 2015 Freedom Act bill, it expands the opportunity for the appellate review of the FISA court decisions, which I think you've had a problem with too, because it has been handed out uncontested, correct?
Say that again, please.
The appellate review, the bill that we will be considering is expanding the opportunity for the appellate review of FISA court decisions, which I think and I can understand, you're saying they can get a FISA order no matter what.
I'm not sure if I understand the question, but I do believe that the court case right now, the way it stands, if the USA Freedom had passed last year, I think there's a chance it might have made the court case moot, because it would have said, oh, Congress has already acted, and Congress now has given an authority for a variation of this, and Congress already fixed the problem. So there's part of me that would like to see the appellate court case go up to the Supreme Court. It's been remanded to a lower court, so I don't know if it's ever getting there. But we ultimately have some questions in our country that won't be decided till we have a Supreme Court case. And one of those questions is, do papers have to be physical and in your house? What if they're digital and lodged somewhere else? Do you have any right of privacy, any Fourth Amendment protection at all for records that are held somewhere else? The current legal opinion doesn't really give any protection to third-party records. I think that needs to be fixed, because I think technology has made it such that our records are no longer going to be real records that you can hold in your hand. I think almost all of our records are going to be virtual and held in space somewhere, and I think you have to still have a personal privacy protection in those.
So the bill that we have proposed before us, it's going to require declassification of FISA court opinions containing significant legal interpretation, which is a positive thing.
There's a lot that I like in the bill. It's just a matter of whether or not I can be convinced that it doesn't allow bulk collection under another name. I'm still worried about that, but I'm open to it. And see, some of these things, this is a very important bill. I mean, we could have a week's discussion on this bill, and amendments, and a process. And the only reason we're getting a little bit of this is because I'm kind of forcing the issue. But I'd like to see the amendments voted on. And all the other stuff we're doing around here is important, but has no deadline. We could have done it next week, 2 weeks from now, all the stuff we're doing right now. So, but anyway, that's what I'm going to be asking for is the ability to present 5 or 6 amendments, vote on them, and then we'll see. And I'm more than willing to talk with the authors of the USA Freedom Act to see if there's a way, but it's going to have to involve maybe some give and take to figure it out.
Well, it sounds like we're not that far apart. I think that we're all going down the same path, trying to find a way to keep the homeland as secure as humanly possible, but protecting the rights of all Americans, and I appreciate that, and I hope that we do. These are important issues, and it's a dangerous world we live in. It's a threatened world that our children are being raised in, and we want to do everything we can to protect them. I know you do too. With that, I think we all come to an agreement that what was done before was wrong. So we all have come unanimously to that agreement. Finding the pathway forward is the one we're working on now. So I appreciate your sincerity and intent to try to reach out and find that, and I hope that you can find that comfort level that we can move forward and still have a protected country. Thank you.
Well, I thank the senator from West Virginia, and I think that he's made some really good points. And I think a lot of us have come to the agreement that there's a problem with bulk collection. I don't think we're yet to everybody. I think we're to a significant number, though, that agree. The court agrees with us. And so I think we are getting closer. One of the groups that we've talked about in looking at where we are on whether this is a constitutional or a legal program is that it's been pretty intriguing to look at the report that comes from the Privacy and Civil Liberties Oversight Board. This is a bipartisan board, and it's a board that was put in place, and I think the appointees are bipartisan appointees. When they met, they came to the conclusion, though, that the bulk collection of records is not warranted and not given sanction by the PATRIOT Act. And they had 4 different reasons why they say that the telephone records program, the bulk collection of our records, does not comply even with the PATRIOT Act. The first reason they say is that there's no connection to any specific FBI investigation at the time of the collection. So basically, when they collect your phone records, they're not even alleging that they're related to any investigation. But that's what the statute says. They're supposed to be relevant to an investigation, but there's no evidence, and nothing's even presented that there is any investigation even going on. The investigation actually starts after they've collected all of your records. So how could Section 215 say that you can collect these records because they're relevant to an investigation that has not yet even begun? They use this big data cache later on when they say that there's going to be an investigation. So I think their reason, number one, is pretty strong, that there can't be a connection or a relevancy because there really is no investigation when they collect your records. The second reasoning of the Privacy Commission was that the records are collected in bulk, potentially encompassing all telephone calling records across the nation. They cannot be regarded as relevant to any investigation without redefining the word relevant in a manner that is circular. Relevant sort of means that there's some kind of criteria that says these records have some pertinence. There's something about these records. There's something about this investigation. Like, for example, someone in the northwest section of Washington, D.C., and we saw something happen there. We're saying we want to look at the records there. Even though it might be bulk collection, it would be at least relevant to some sort of investigation. There would be some pertinent factor. But they're not electing any, they're just collecting everybody's records. It's completely without any relevancy, and I love the way they put it. that this would not be relevant unless we redefine the word relevant in a manner that is circular, unlimited in scope, and out of step with the case law from analogous legal contexts involving the production of records. The third reason why the Privacy Board said that this program is not legal is that it operates by putting telephone companies under an obligation to furnish new calling records on a daily basis as they are generated, instead of turning over records they already have in their possession. This is an approach lacking foundation in the statute, one that is inconsistent with FISA as a whole. The final reason they say that this program is illegal, this is the President's own Privacy Commission, is that the statute permits only the FBI to obtain items for use in investigations, did not authorize the NSA to do anything. So Section 215 of the PATRIOT Act is what they're saying they're using as justification. It allows the FBI to collect records. It doesn't allow the NSA at all. So they're using a statute that was intended for the FBI to say the NSA can do this. So I think the reasons are pretty clear, 4 succinct reasons why the PATRIOT Act does not justify the collection of these records. The next thing the Policy Committee looked at was they looked at and they tried to decide whether there's been any practical effect. And I know Senator Leahy was a part of this in looking at whether or not any of these things actually did catch terrorists. But this is what they conclude, and they actually looked at the classified data. So the Privacy and Civil Liberties Commission looked at the data, looked at the classified data, and this is their conclusion. We conclude that Section 215 program, the bulk collection, has shown minimal value in safeguarding the nation from terrorism. We have not identified a single instance involving a threat to the United States in which the bulk collection program made a concrete difference in the outcome of a counterterrorism investigation. Those are pretty strong words. The Policy and Civil Liberties Board, commissioned by the President, that's bipartisan, looked at the classified data and said they didn't find a single incident, not one incident, in which it made a concrete difference in the outcome of a counterterrorism investigation. Moreover, we are aware of no instance in which the program directly contributed to the discovery of a previously unknown terrorist. What does this mean? We're not like pushing a button and generating terrorists out of this. The terrorists are coming from real information. And you have to realize this misinformation and this wrong-headed information has been used forever, for 15 years, to justify the fact that we should give up on the Fourth Amendment and we should give up on protections. Over and over again, people say, if we'd only had the Patriot Act, if we'd have had the Patriot Act, we wouldn't have had 9/11. The 2 terrorists they claim we would have gotten were in San Diego. We already knew about them. An informant lived with them for a year. The FBI wasn't talking to the CIA, and they weren't looking at lists, and they didn't know they'd come back. The CIA didn't know. Had nothing to do with having bulk collection of our records. We knew about these people. It was crummy work. It was people not doing their job. And I repeat again, no one was ever fired. We gave rewards. We gave medals of honor to everybody in the intelligence community, and no one was ever fired. There were some true heroes. The FBI agent in Arizona, the FBI agent in Minnesota, who actually discovered potential hijackers. 20th hijacker was captured a month before 9/11. That's the person who should have gotten the Medal of Honor. The person who wouldn't listen to him should have been fired. I have no understanding or awareness that anybody was ever fired over 9/11. The Policy and Civil Liberties Board goes on to say that our review suggests that Section 215 of the Patriot Act, the bulk collection of records, offers little unique value. They explore a little bit of whether or not there is a privacy problem with collecting all these records and what are the implications of collecting these records. The government's collection of a person's entire telephone calling history has a significant and detrimental effect on an individual's privacy. Beyond such individual privacy intrusions, permitting the government to routinely collect the calling records of the entire nation fundamentally shifts the balance of power between the states and its citizens, between the state and its citizens. With its power of compulsion and criminal prosecution, the government poses unique threats to privacy when it collects data on its own citizens. Compound this with the fact that the government, you could say, well, they're just collecting this data at a lower standard, but if you're not a terrorist, you don't have to worry. But here's the problem. They're collecting this data with a lower standard, a less than constitutional standard, but then they're also prosecuting you for domestic crime. Section 213 of the PATRIOT Act is being used 99.5% of the time for domestic crime. We're putting drug dealers in jail. That's another question and another story, but then we should vote on it as a country. Okay, for drug dealers, we're not going to have the Constitution anymore. We're going to have the Patriot Act for drug dealers. Let's be honest about it. The war on drugs has had a disproportionate impact on people of color. And so you have to admit to all the young black men and all the young brown men you've put in prison that we're no longer using the Constitution to stick you in prison. We're using the Patriot Act to put you in prison. We need to be honest with people. If the Patriot Act is about terrorism, they should adopt my amendment that says you can't be put in jail for a domestic crime under the Patriot Act. Why? Because the Patriot Act has dumbed down and loosened the standards. We don't have probable cause, we have relevance. And realize that relevance, as they say in the commission, has become completely circular and devoid of meaning if you're saying that all the records in the country are somehow relevant to an investigation that has not yet begun. The other point, they make a great point here about the fact that not only does this stifle or invade your privacy, it may well stifle your speech and your association. If you're going to be associated with, minority causes, unpopular causes, whether you're a kid from the North that went down to be in favor of civil rights, whether or not you're someone who belongs to the NAACP or the ACLU. They say yet, even though there's no evidence of abuse, and that's just a big argument. Everybody says, well, there's never been any abuse, so it's fine to keep doing this. They say yet, while the danger of abuse may seem remote, given historical abuse of personal information by the government during the 20th century, the risk is more than theoretical. I couldn't agree more. Moreover, the bulk collection of telephone records can be expected to have a chilling effect on the free exercise of speech and association, because individuals and groups engaged in sensitive or controversial work have less reason to trust in the confidentiality of their relationships as revealed by their calling patterns. Realize that they're taking your phone records, your calling list, your buddy list, your ISP address, your email, and they're integrating this into some network where they can pull your name up and find out who are all your buddies, who are all your friends, who are all your Facebook friends. Realize what the potential danger is of having so much information, so much of a dossier on every American citizen, even if they're not using it. But when you think that, well, this is fine because we're not doing it and good people are running these agencies, realize that the head of the agency lied to us about this program at all. He said it didn't exist. So when you get to be trusting these people to protect your individual information, realize that at the very top of the intelligence community, the most famous person in our country dealing with intelligence lied to a congressional committee and said that this program did not even exist. The report goes on to say that the inability to expect privacy vis-a-vis the government in one's telephone communications means that people engaged in wholly lawful activities, but who for reasons justifiably do not wish the government to know about their communications, must either forego such activities, reduce their frequency, or take costly measures to hide them from the government surveillance. The telephone records program thus hinders the ability of advocacy organizations to communicate confidentially with members, donors, legislators, whistleblowers, members of the public. Initially in the 70s, when we set up the surveillance courts, the security courts, the FISA courts, they were done with individualized warrants. They got information through individualized warrants. Beginning in 2004, though, the role of the security court changed when the government approached the court with its first request to approve a program involving what is now referred to as bulk collection. For the first several years we did bulk collection, they just did it. They just said it was under the inherent authorities of the president. This should scare us because there are people who believe that the inherent authorities of the president are unlimited. That would not be a president. There would be another name for that. But if there are no limits to what the president can do, there's another name for it, and it's not president. The commission goes on to say that the judge's decision, their decision-making, would be greatly enhanced if they could hear opposing views. So the Privacy Commission advocates exactly what I'm advocating for, that you should have a lawyer in there with you and that there should be an adversarial type of procedure. Because the thing is that it's like any other dispute. If you've ever heard two people arguing, figuring out the truth is listening to both sides and trying to gather what the truth is. So I think that we'd get to the truth a lot more if we had someone asking questions. Realize also that Section 215 of the PATRIOT Act says that the information has to be relevant to an investigation. Without having someone in there to argue your case, the court appears to have not really had a great deal of discussion, or to my mind, thought about whether bulk collection is somehow relevant. You might argue that if there were opposing sides, like in a traditional court, that maybe someone would stand up and say to the judge, how can this be relevant? And what investigation is it relevant to? See, I think the FISA court became such a rubber stamp that you weren't even having these questions asked. Because how could you ask that question if you're an advocate for somebody who doesn't want to give up their information? How could you ask the question whether it's relevant to an investigation, and then the government would say, well, yeah, we're going to do it. It'll be relevant when we do an investigation. No court, you would think, would understand or accept that if it were an adversarial procedure where you have a lawyer on both sides. I don't think you truly can have justice. You can't truly have a court. I think you can have a court that meets in secret. I think courts can protect individual names, and I want them to. And I thought Senator Wyden made a great point when he was out here. Intelligence activities, at their core, we have to protect the names of operatives. You don't want the code out there. Like if we have a great code and we're stealing information from our enemies and we're eavesdropping on our enemies, we don't want the code out there. It shows how smart we are and how our technology works. But if we're going to do something like collect the records of all Americans, that's a constitutional question. And you can have opinions on both sides of it. I don't think there's much of a valid constitutional reason for believing in this, but you can have an opinion. In a democratic republic, we could argue these points back and forth, but you wouldn't have the ability, you really would have to have the ability to have a discussion over these things. Because I think that without that, I don't think that we can actually get to justice.
Mr. President.
Does the senator from Kentucky yield for a question?
I would yield for a question, but not yield the floor.
Mr. President, I am wondering whether the senator from Kentucky would be good enough to confirm for me where I think the issue is that is before the Senate today. So if I might, I will speak for a few minutes about what I think is the core issue before us on the floor and then ask the senator whether he would confirm that this is his understanding as well. Because just at the outset, I'll say it's relatively rare for my colleague from Kentucky and I to come to the floor in agreement on an issue. But it has happened before on exactly this issue. And I think it's important that it be clear to folks that there are concerns on both sides of the aisle on the critical underlying issues about how we balance privacy and liberty, security and our civil liberties. For a decade, nearly a decade, our government's operated a program that collects massive amounts of information from innocent Americans without any specific suspicion they've done anything wrong. And let me put that another way. For years, any American's communications data could have been tracked and collected by the government, whether or not they were suspected of a crime. That program's been carried out under Section 215 of the PATRIOT Act based on flimsy or mistaken interpretations of the original law, all in the name of our national security. Yet the bulk collection program has had disputed and not arguably clear benefit to our national security. There's not one clear publicly confirmed instance of a plot being foiled because of this Section 215 program. I've long been concerned about the scope and the reach of our intelligence community's bulk collection program. That's why in 2011 I voted, along with my colleague from Kentucky, against the straight reauthorization of the Patriot Act. I believed then, as I believe now, it would be irresponsible for Congress to continue reauthorizing the law without taking steps to address concerns about unlawful surveillance it has allowed, particularly given the fact that earlier this month, a U.S. federal circuit court specifically deemed this program illegal. Fortunately, we have an alternative, which I believe the senator from Kentucky has been expounding on behalf of, the USA Freedom Act, a bipartisan bill passed by the House just last week by an overwhelming margin. I think it was 338 to 88. It would end bulk collection by only allowing the federal government to seek call records retained by the telecommunications industry once it has established the record is relevant to an ongoing investigation. Records would no longer be stored by the government, but remain in the hands of telecommunications companies, which, under FCC rules, in order to ensure that there are customer access to records in the case of disputes, are retained for 18 months. This bill strikes an important balance by protecting America's privacy and ensuring our government can still keep our nation safe. In fact, there are some who might argue that the USA Freedom Act would allow a stronger, more robust, and more effective series of actions to keep our nation safe. I urge my colleagues to support it. I know these are difficult decisions for us to make, and I know we all have concern about our nation's security, but we have to all have concerns about our nation's freedom. We fought for it from the very beginning of our country. And I want to just thank and salute members here, colleagues, and in particular my colleague from Kentucky, for being insistent that we have clarity about time. We were told 4 years ago, when the reauthorization fight was happening, that time had run out and that we needed to reauthorize it without considering needed reforms that were discussed and debated in the Judiciary Committee. 2 years ago, some of the core elements of this were exposed to the world, and a lot of my constituents raised legitimate and serious concerns about it. Whether we are being asked to extend it for 2 weeks or 2 days or 2 hours, I think time has run out for us to even discuss reauthorizing a program that has explicitly been held illegal, and we instead need to come together, take up, and pass the USA Freedom Act. Would my colleague from Kentucky confirm that that is the situation on the floor at the moment, and on behalf of which you've been speaking?
I think what is still unclear to me is what will be taken up and what votes there will be on this. I think that the debate is a really important one. It's one that we should engage in and have a significant time to talk about, that there should be amendments offered. And as you know, sometimes the amendments get offered and then things sort of fall away. And I want to ensure that on something this important that comes up only once every 3 years, to which the court just below the Supreme Court has said that we're doing something illegally, that we don't just gloss over and just say, oh, we're going to keep on doing something that the courts have said is illegal. As far as the end result of where it comes, I want to end bulk collection, so I agree with all of the people on the USA Freedom side. I'm a little concerned that we might be transferring government bulk collection for privately held bulk collection. In the selector terms that they use in the USA Freedom Act, it says person, it says specific person, and I think it defines person, though it's still including corporation. My concern is that you could write into the specific person Verizon again, and we're back where we started. So if we could get to a point of, one, allowing some amendments to be voted on, and maybe changing it such that you can't have, see, to me the biggest issue here is a general versus a specific warrant. I don't want warrants that you can get everybody's records all at once, or even one company's. I want the warrant to say, and I'm fine with getting terrorists. I want to get terrorists. If it's John Doe's a potential terrorist, put his name on it. You can go as deep as you want into the phone records, but do specific warrants. But I don't like it if you just say, I want everybody's records from a phone company. And so I'm just concerned, are we trading one bulk collection for another form? And I need to be a little more reassured on that. I think there might be room for it if people are open to discussion on how we could figure out a way to get something through, because it's going to be difficult, as you know, to get to 60. It's going to be hard either way. The other side, once they want the bulk collection. Many people want the bulk collection. They want more of it. And then there's at least half of us that think it's a wrong thing to do. I don't know the end outcome, but I was uncertain enough about the outcome that I came today to try to draw attention to it. And if I had a request today, it would be for both leaderships is to let amendments to go forward, that we agree on having a pretty free amendment process. This is only every 3 years, and it's a big deal. We don't have many legislation come before us where an activity has been said to be illegal by an appellate court, and we continue to do it, and then people want to advocate to continue to do something that's illegal. But I'm going to try to see what I can get. I'm hoping to get an answer maybe today from leadership on will they allow amendments to this, and I want to be pretty certain that's going to happen because they seem to fall away sometimes.
Does the senator from Kentucky yield for a question?
I would like to continue to keep the floor, but we'll yield for a question without losing the floor.
Mr. President, I want to visit the senator from Kentucky for what he's doing. I think this is very, very important. And I stand here today with my colleagues from both sides of the aisle to protect Americans' privacy rights. I am very concerned by the overreach we have seen in the name of national security. And I oppose efforts to reauthorize any piece of it without real reforms. Folks in Montana know that I've been an opponent of the PATRIOT Act since it was signed into law. Why? Because the PATRIOT Act violates law-abiding citizens' right to privacy, something that we hold dearly in this country. Now, we do need to make this country as secure as we possibly can, but we cannot do that at the expense of our constitutional rights. It's been talked about here earlier today. A federal court recently ruled that the NSA bulk data collection is illegal, flat illegal. So keep in mind that the NSA used the PATRIOT Act to authorize those data collections. Yet here, in the United States Senate, some of our colleagues think that we should reauthorize those expiring provisions without even having a debate on their merits. We've seen this before. It's happened several times since I've been here in the Senate. Trying to jam an extension of the PATRIOT Act through the Senate at the last minute is not fair to this body, and it's not fair at all to the American people. We deserve a real debate on privacy and security here in the United States Senate. It's too important of an issue not to. We have to put some sideboards on our national intelligence agencies so that they can keep us safe without violating our constitutional rights. We need a real debate on this issue. Last week, the majority made a decision to deprive the Senate and the public of the debate by taking up a trade bill, which we could have passed in June. No doubt about it, we're approaching the Memorial Day recess. Some folks are anxious to go home, but we got work to do. I will continue to work with my colleagues to ensure that we make real reforms to the PATRIOT Act. If the people in this body don't know this important, they don't know the Constitution. And I would just say I want to thank everybody who spoke here today. We need to have a debate. We need to have a debate on what the PATRIOT Act is about, how it's being utilized, and how we need to move forward. An extension is not acceptable. With that, Mr. Chairman, I would yield the floor back to the senator from Kentucky and thank him for the work that he's done on this issue.
I want to thank the senator from Montana, and I think further evidence that there is bipartisan support for the Constitution and that the Patriot Act went too far. We've heard from both senators from Montana, from opposite parties, who both want to defend the individual, want to defend the Bill of Rights, and think that we've let the government go too far. I think the American people agree with this as well. I think without question, and this is one of those things that's kind of perplexing if you think about it. If you ask most Americans, if you do a poll or a survey or ask most Americans, should the government be allowed to look at your phone records without any suspicion that you've committed a crime? I think it's a very low number who think that. But then when you get to Washington, it's almost the opposite. You have people in Washington who have, I think, viewpoints that are really, really out of step with what the American people want. The American people really, I think, have decided that the bulk collection of records is wrong, that it is unconstitutional. The second highest court in the land has said that it's illegal. And yet you still have a significant body of people in this country saying, not only keep doing it, let's do more of it. The problem is if we're going to allow records to be collected without individualized suspicion, what you're doing is allowing something, when we talk about bulk collection, that has no sort of determinants for what suspicion is. You can imagine what the danger of that is if you apply that to everything. Also, in an age where we have computers that can analyze and hold so much information, and they're building them bigger and bigger and grabbing more and more and more and processing this information, the great dangers that could come from this. I wrote something about 1984 a couple of years ago, and I said when I read it the first time, you know, New Big Brother, you know, it was the danger of all these things, and I thought, oh, this is terrible. But, you know, I kind of felt comforted. I read it probably in 1978. We didn't have the technology to eavesdrop on everyone. We didn't have the technology to know everyone's whereabouts. We didn't have the technology to have cameras in every house. You know, in the book, they talk about looking at people back and forth through two-way televisions and monitoring everybody's, you know, they had to be careful where books were placed. You had to read in secret, basically. But because the technology didn't exist when I read 1984, I wasn't as concerned about it. But the thing is that you don't lose your freedom in one fell swoop. You lose it a little bit at a time. People say, well, the people doing this are good people. You know, it's like the president said. When the president signed legislation a few years ago that said that an American citizen can be detained without a trial, he said, but I am a good man and I won't use this power. It's sort of a fundamental misunderstanding of law and the rule of law that you think that the goodness of yourself or the goodness of the individuals around you somehow is the protection of the law. The law is really to protect you against bad people. The law is to protect you when bad people get in office. The law, and those who believe in the rule of law, is based on the fact that there's an understanding that in the time of history, people are democratically elected who are bad people. And that people, once given power, become addicted to it, and they want more of it. Lincoln once wrote that any man can stand adversity, but if you want to truly challenge a man, give him power. That's what we're talking about here. We're talking about unlimited power. We're not even talking about power that's constrained by law at all. The whole idea that the Patriot Act has anything to do with the bulk collection is a farce. The President's Privacy Commission has really put this in bold for us, that really there is nothing about the Patriot Act that has any resemblance to what we're doing with bulk collection. So that's not only not the rule of law, that is people within government, within the executive branch, that have made the decision that they're going to do whatever they want. One of the things that worries me about this debate, and I think it's good that we're having the debate, but there's apparently a section of the Patriot Act, as we passed the last time, that says if the Patriot Act is not extended, all things previously being investigated before will continue. So we really kind of have a perpetual Patriot Act, if you will. That worries me a little bit, but then again, it worries me even more that we're not even really paying attention to the Patriot Act. We are doing whatever we want. It is sort of a lawlessness that allows us to collect bulk records because there is no relevance to an investigation. As they said in the Privacy Commission, we're collecting the records before there's any investigation. So there is no relevancy to an investigation. The investigation hasn't started yet. Unless the investigation could be defined as everything. And I like the way they put it. They said we'd have to destroy the definition of relevancy to believe that there is any component of relevancy to this investigation. But we're collecting records of every American all of the time right now. It may not be just phone records. They say the biggest source of collection right now is probably actually through Section 702 of FISA, of the FISA amendments. We're not exactly clear what gets scooped up in that. And once again, if these are the records of foreigners, if these are the records people bent on attacking us, I'm all for getting that. But the way they're collected, and by some allegations intentionally so, we are sometimes targeting a foreigner so we don't have to use a standard at all in order to get information on an American. So let's say that they want information on you. I'm not sure why, because some of this is being used for drug crimes and domestic crime. But let's say they want information on you and they don't want to get a warrant, or a judge says no. In fact, that's sometimes happening, that a FISA court judge is saying no, and then they're using one of these other end-around ways that don't even require a FISA court judge. The level of lawlessness is appalling. The level of lawlessness is astounding. It disappoints me that the president, who was once considered by some to be somewhat of a civil libertarian, does nothing. When the president ran for office, the president said that national security letters ought to be signed by judges. He was in the exact same place where I am on civil liberties with regard to these warrants, the national security letters. Yet his administration issues them by the hundreds of thousands. I think they aren't even reporting these anymore for us. They reported them for a few years, but we're no longer getting the information. But it disappoints me that the president's not really willing to do anything about this. The president could end the bulk collection tomorrow. It is done by executive order. It could be undone by executive order. It is disingenuous at the very least that the president says, oh, or else we're going to balance liberty and security. Well, no, he's not. He's not balancing anything. He's just continuing to collect all of our records without a warrant. He's continuing to do bulk or general collection of records without a warrant. I think the American people are ready for us to be done with this. My hope is that in today that we will call attention to this, and that the American people will say, who are these people that want to keep collecting our records without a warrant? And why do they still want to do this when the people who have investigated it have determined that no one has been captured by this program? No one has been uniquely identified by this program. So there really is a consideration of whether or not we're going to listen to the American people. Are we going to wake up? Are we a representative body? The other question is, are we going to allow a debate over something that only comes around every 3 years? Or are we going to say, my goodness, it's the weekend and it's Memorial Day weekend and we're up against a deadline, so we just don't have time for listening to this. We don't have time to talk about the Bill of Rights because we just don't have time. I know it's been 3 years that we've known this date was coming up, but we don't have time. I think at the very least we could make time. And that's my request today. My request from the leadership of both sides of the aisle is, can we not make time? You know, there's at least 10 or 15 of us that will co-sponsor about 5 or 6 amendments that we want votes on. And frankly, I think the mood of the country, we have a chance on a few of these. I think, for example, the idea that we're using a lower or a less than constitutional standard to gather information that we say is for terrorism, but then we're going to put people in jail domestically for crimes that are completely and entirely unrelated to terrorism. I'd like to see how the vote turns out on that. Whether or not we can use information gathered in a non-constitutional